the different ways mediations can end. Part of the series, Mediation with or Without Attorneys, with Ty Bodoni. That is your topic for today. Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is Mac Pierre-Louis, attorney, mediator, and arbitrator, working throughout Florida and Texas.
And Natalia Łowska-Czajka, advocate, mediator, and arbitrator from Warsaw, Poland.
And Ty Bordoni, Director of Mediation at CPLS, PA in Central Florida, a primary mediation trainer and a full-time mediator.
Awesome. So welcome back, Ty and Talia, as always. So before we proceed, just wanted to let everyone know that Natalia and I recently updated our website. And so if you have a chance, check out alaskapier.com, because there you'll be able to have a gateway to all the different spots on the internet where we are, including my own page, which is macpierre.com, and Natalia's page, which is nataliaalaska.com. And of course, we're on Twitter. So that's a really cool way to follow us as well, because it'll help you stay in connection with all the things that Instant Mediations is doing and our own personal law practices. So that's at Instant Mediations, of course, and at Alaska Pierre. So that's just a little public announcement. All right.
Mhm.
So Ty, the topic for today is the different ways mediations can end. And this is an interesting topic because, well, let's face it, every mediation comes to an end, but people who go into the mediations might feel that their only options are either they get everything or they lose everything. All right. Where they go in there thinking or acting like the mediator is somehow a judge or an arbitrator that's going to force some kind of resolution. And so we wanted to just talk today about the different, multiple ways mediations can end. It's not just win, lose, or draw. There are flexible outcomes at mediations. And Ty, why don't you start and let us know what's I guess one of the ways mediations can typically end.
Right, always good to be with you guys.
Our pleasure.
I love our talks. And interestingly, as you were talking, it's not just how mediations can end. I think it's also the mediator needs to allow themselves to recognize the inherent flexibility, because even mediators, we get stuck with I want a settlement agreement. I want what's the agreement? Let's get them to an agreement. And it's not always about the agreement, right? It's about what's the best outcome for these parties in this individual case, in this moment today, because sometimes you mediate too late, sometimes you mediate too early, sometimes there's just the great thing about mediation is, sometimes we have to recognize, well, what's the miscommunication? And in order to help the parties get to a place where they can be successful, we have to figure out what the obstacles are, where things are is it the right time? What do they need? And so flexibility is a mediator's middle name. And the mediator also has to remember that there can be many options. And interestingly, I think you mentioned, Mac, that when you give your opening statement, you like to tell parties that there can be, different kinds of outcomes. And so I think the one I want to start with is that every mediation can't be an agreement. And so you can have a successful impasse is the one I'll start with and what that means.
Mm-hmm. Yeah. Go ahead.
What does that mean for you guys? A
Okay.
successful
So,
impasse.
of course, the most satisfactory solution and resolution in the mediation is the agreement where
Yeah.
everybody's like, wow, yes, we did it. Finally, we have a success. And this is how it is being advertised for in mediation, that you can have your settlement, you feel you win because mediation settlement agreement is a win win for everybody. Sometimes including the mediator as well, because they are happy for themselves. So they don't take parts, but they are happy that they helped people reach their own agreement. And that gives a lot of satisfaction, especially when people coming into mediation were on totally opposite ends, and just bringing them closer, bringing them to think the same way, to agree on something that was unimaginable at the very beginning of the process is the very heart of the mediation, and this is probably what motivates mediator to do their job.
I agree.
But then what Ty mentioned, the successful impasse. Sometimes you can be happy that you reach an impasse, and that can have many faces. One of the faces might be that you reach the point when you make people think about what they want, how they want to behave, make them realize something very important. That's one. And the second one I can think of is also when people go, reach an impasse because, for example, they see a certain danger in what they were agreeing. They felt pushed. But again, that made them realize something very important about the situation they're in, about the other party they are mediating with, and maybe learn something for the future. And when we say a successful impasse, I do believe we also mean that after a successful impasse, the parties often come back to mediation
Mm,
with fresh thoughts, with fresh motivation, and sometimes we do have this happy ending with a good mediated settlement agreement.
mm. Right.
Yeah.
Let me add to that, if I may, because I like how you said that. And sometimes mediation isn't the place for the agreement, but you can have a successful impasse because you set they maybe they left with a plan of action, or just by recognizing what was needed, setting that in motion, they can then get to the agreement. The attorneys can, or it can still though be resolved because of what now we all know. This is what you do. You do this, and then you guys are done. You're just not going to do it here today, but great job, everybody, kind of thing, right? So well said. I'm sorry, Mac. I think you were going to
Yeah.
say something.
No, and I wanted to add one thing. First off, to any potential mediation party out there, know something. Us mediators, we don't really like impasses. I mean, me anyway. I like settlement agreements. Okay, you don't realize the thrill you get even after an exhausting day of helping parties, right? Of caucusing, of going back and forth. It's labor intensive, but once you've gotten parties to resolve their differences and make peace and move on, especially for the betterment of their children, it makes you feel really good at the end of the day. Okay, but when you as a mediator get an impasse, it makes you kind of think, did I do everything? Was there something else that could have been done differently?
Yeah.
Because let's face it, we become part of your lives whenever we go through this. So there's a certain level of disappointment, I guess. It's not high, but there is, because we actually genuinely want people to make peace. The other thing I was going to say
Well said.
is, then what is a successful impasse to me?
Mm,
It is one where at least the parties leave, and I think Natalia kind of hit on this a little bit. At least the parties leave with a certain set of skills or a certain set of knowledge now that can help into the
mm,
future.
right.
Usually, what I've told people is this: that is, look, if this doesn't work out today and we have an impasse, I want you guys to at least know what you're actually fighting about. Like, get the issues
Right.
reduced to, okay, clarity. For clarity's sake, what is it that
Right.
is the crux of the matter? And a lot of times, like Natalia said, when people then, wake up the next day and they think about it, sometimes they make peace, they will come back to mediation, or they wrap it up themselves. It's surprising how many times that happens.
Right.
And so I don't really foresee impasse as the end of the world. Disappointed, but people sometimes still work it out anyway because they at least now know what the issues are.
Right. Or at the very least, let's just, and I love everything that we said. I love the optimism, but what about those instances when they just can't see eye to eye and there is just an impasse? Well, and because a lot of mediations end that way. And so, but I still want to be positive for the parties. And so sometimes the point of mediation isn't agreement. It is, in fact, impasse. But that's so that the parties, well, now your case can move forward in the appropriate manner. And now you can go. Maybe some people do need to go to trial. Now you can, right? So there's a lot of good reasons for impasse. Let's be honest.
So, a successful impasse as a door opening solution to go to the court, for example, for those who still need to
Yeah.
really stay in fight, because this is what it actually means, staying with their problem unresolved. So far, we touched upon an agreement that makes everybody happy, or at least it should. Then impasse, which means no settlement. But also what is interesting is that mediation can be perceived as a process where you achieve certain goals step by step.
Step by
And
step.
that leads us to other ways mediation can end. Sometimes we are mature enough only to settle upon certain issues. That brings us to a partial agreement. With the partial agreement, we already have something settled. We know where we are. And if we perceive the other part of the matter unresolvable, we can go to the court and let the judge decide. However, this is also a great thing to have either this partial settlement on certain issues or temporary settlement. And I wanted to have your views on it, because this temporary settlement is a magical instrument in mediation for me, because it is like a temporary order in the court sometimes, but it is an agreed temporary solution that we try upon. So for parties and especially in the family matters, when women, men, but sometimes really mothers express so many concerns. Oh, I don't know if I can entrust the child. I don't know if he's able to really do it. If he has conditions, let us try. That will be this temporary solution. We will try. We'll meet again on the next session, and you'll tell me how it all went. Let us try. What do you think about it?
Yeah, I couldn't agree more. To start with the partial, the other great thing about a partial is, and I'll tell folks, look, there are some issues you might agree upon and some you might not agree upon. Please don't worry, we can reserve, and you can of course let the court decide those issues, and when that's appropriate, and that happens quite often enough. What I like to tell the parties is, look, when you go to trial, this is when it's going to get expensive for you. This is when now it's going to take longer. But if we can come to agreement on some issues, that's that many less issues that you have to go and litigate, right? And so you'll save some time and you'll save some money. And in some instances, that's a good solution for some folks. And for any one of a number of other reasons, partial agreements, can help reduce the issues and can help the parties move forward to some extent. And temporary agreements are also really, really, great opportunities for the parties as well, because just like you said, there's plenty of instances like that, and there's plenty of other. Every case is individual in and of itself. But when the mediator recognizes, we're not at the place yet where the parties are able to, see eye to eye, come to agreement, there's doubts or what have you, that temporary agreement, with the mediator's help in structuring it the right way, right? Because the great thing about being the mediator, being the third party, is you're not emotionally invested. And so we can be the rational party sometimes even, some other parties can be. But the point of the matter is, so let's see how things work. Let's give one of the parties some rope, and let's see, everyone is either going to jump rope or someone's going to hang themselves with that rope. But when they come back, the hope is, how did it go? What worked? What didn't work? And does this get you ready to then go to to have that final agreement? And every case is a little different, but when it works really, really, really well. Or when they come back, it fell apart. It didn't work. But it can be really, really quite helpful, especially in those really tough cases, right? And so again, the point of the matter is the mediator recognizing what do they need right now, and then plus you see it so many different ways and so many different times. It's actually a really convenient and an easy one to kind of recognize and try to implement for that is to offer to the parties. How about a temporary? Have you considered, trying it, and then let's come back and let's see how it worked. And or sometimes the parties, like if you have a pro se party, you get the sense and you recognize, ooh, they might need some legal advice on. So why don't we work on this? And why don't you go talk to someone? And when we come back, if you have, we may be able to. So there's temporaries are great solutions when appropriate.
Yeah, so temporary, I think people might be surprised by just how many times parties do a temporary agreement and then they don't come back to mediation at all
Why?
because they don't need to,
Because
right?
they
Or
don't.
they do a partial agreement and then they don't go to court to get the rest adjudicated. It's so a lot of times that's another result of doing a partial or a temporary because parties just needed to have somebody help them with the
Yeah.
first leg of the race, and then they can kind of finish the rest themselves because
Sometimes.
now they've seen, okay, this we can work it out. If we were able to make peace on this part, why not the rest?
That's right.
So one other thing is people need to know that there's partial, there's temporary, but there could also be a, partial full settlement, partial temp or
It could be
partial
a partial
temporary settlement,
temporary. Yeah.
right? Because so there's a there's a multiple combinations.
There are.
For
Yeah.
example, I will deal with a case, mediating a case, and the first question is, to all the parties, okay, guys, are we trying to shoot for a full agreement today? Because we're only set for a temporary orders hearing mediation. We can do a temporary orders mediation, but if you guys really want this whole case to be wrapped up, why don't we go for a full settlement? Okay, so in any one of those, whether it's a temporary agreement or a full agreement, we can also have them be partial.
Yeah. A
So
hybrid.
there's so many different combinations of ways that
Yeah.
the case could be resolved.
Yeah. Yeah. Right. That's right. And the mediator needs to, again, it's what do the parties need right now, today? And it can be any one of a number of combinations, and we have to think out of the box as well, right? I couldn't agree with you more. And sometimes the headings on the agreements are really long, but it is what it is. And then what about what else? What other kinds of agreements are there?
Yeah,
I
Natalia, you were gonna say something?
Yes, I wanted to say that maybe someone who might be listening or watching might be thinking, so why? I go to mediation just to reach an agreement, and now you're telling me that there is such a variety, so I don't really know what I come for. Mediation is like a magical process. You realize what you are going to achieve during the process. So even if your intentions are for the best, to have the full settlement, you can see how much work sometimes it takes from the mediators and from the parties to agree on something. How many different proposals can or need to go back and forth so that finally you have a little piece done.
Yeah.
So mediation is also a process of creation. You
Mm-hmm.
create the outcome. And sometimes all of that needs time. And therefore, another way a mediation session can end is by adjournment. That means at this stage, after reaching the planned time for mediation session today, which in Poland is 2 hours, and I understand in Texas is 4 or 8 hours,
Wow.
you say to yourself, okay, we adjourn, but think about this and this and this and come prepared. So it's like a little homework the parties get to come better prepared. Sometimes this homework can be consult your lawyers or find
Yeah.
someone who will advise you. But
Yeah.
sometimes it might be check the numbers.
Hmm.
If you are doing the marital settlement on division of property. So there is a lot of things sometimes you need to, and also sometimes people come and they don't know what to expect from mediation. So it is like, let us say, like a dry try. You go and see the very first session how it goes, and so that the second one can go smoother because you already know where you are, you already know what to say, you're far more relaxed, and
Right.
just build a better rapport with the mediator.
And the mediated with the parties. Yeah, absolutely. Um, and then interestingly as well, I used to kind of think an adjournment was all or nothing, and there was continuation or adjournment, and adjournment is because the mediator says, "Oh, we must adjourn. Something has happened," or and so I think the interesting thing, like I just had a mediation where everybody was really pressed for time. We were coming back, but we didn't know exactly which day. We think we knew which day, and so I like to give, again, flexibility, the mediator's, mental name. Why do I have to type up a continuation agreement and spend another half hour or 15 minutes or 45 minutes, send things off to the parties, when if the parties can simply agree, it's going to be this day at this time. Yes, yes, yes. Okay. Why don't we just adjourn it to that? And then the mediator can just say, the mediator has adjourned it to this day and this time. And so adjournment can be a good tool for a mediator if something happens. Like we have to ensure that everyone's right to self-determination is intact. And so there could be any one of a number of instances when there's, I don't know, an imbalance of power or something just didn't go exactly right. And we need to make sure that that opportunity happens. And so we can adjourn it if we need to purposefully, and or in the right circumstances to help the parties out, you can adjourn as well, so long as everybody is, comfortable with it. But a lot of times we'll just continue. We all agree. Oh, shall we continue? Yes, yes, we shall. Okay, and for this day, great. And then you write it down, and then everybody signs. So there's just again flexibility with respect to our tools, right? And so yesterday, for instance, I had a mediation, and that flexibility allowed everyone to kind of breathe a sigh of relief, get off, mediate, get leave, and go do the things that they had to do, and know, okay, no, we're coming back. The mediator is going to adjourn it for, so what do they need? What helps the parties best, right? Like you said, we're building relationships, we're building rapport, right? When we get these warring parties to the point where they're trusting us, and then we help them by saying, I think this is the best way. In that moment, you're all by yourself as a mediator, and you have to figure out what's the best solution. And because it's no black and white as much as there's gray, and what's the best, easiest thing that's going to cause the least waves, is the conduit to help these, because it's delicate sometimes. Every word you're choosing very carefully, and you're getting these warring parties to a very precarious yet stable temporary peace agreement, and you don't want to do anything that's going to make it blow up. So anyway, the point of the matter is, right, what is it that they need? So a continuation, an adjournment, depending on what's going on, one or the other can be the right tool. So again, more tools in the mediator's toolbox, so to speak.
Yeah, absolutely. And my only thoughts about um, a recess or a continuation, and I can see why you differentiate recess and continuation from adjournment. I get it. I can't
If needed.
imagine though. Yeah, well, I can't imagine adjourning a mediation without having a date pre-planned. Do you typically do that?
So I just did. but we think we knew the date, and it was
Okay.
pretty. But I'll have the flexibility to then. And I said, okay, so everyone will get back to me by this date,
Okay.
because if I see everyone working in good faith, then it's okay, right?
Yeah.
If they're not in good faith, or something specifically happened that's no good, and depending on how the mediator can just set it. But again, it depends. Where's it coming from? What's the program you're in? What kind of mediation? What's the authority? You know, is there an administrative order? Is there a court order? I mean, you know, you have taking all that into
Yeah.
account. Excuse me. The mediator says, "Ooh, I can do this, this, and this." You know, and so we
Yeah.
have to help them choose
Yeah.
the best options. And sometimes it's a great collaboration between the parties. You know, you ever had those mediations where the attorneys and the mediator we're all working really well to come up with that what's the best way, or so it can be a great process as well, right? When everyone kind of puts their heads together and is really trying to find an appropriate outcome.
Yeah, no, I guess you're right. We have done it where we will say by us, you guys will return back to mediation by a certain date,
Right, sure. Yeah.
or yeah,
Within 60 days.
yeah, and the parties have to just to work it out, and
Mhm.
hopefully it works. But I like having a specific date,
I do too.
a few weeks or months out, so that the people know and are prepared. And finally, the last point I wanted to make is the most common reason I find that we typically recess or continue a mediation is to allow people to just go do more research. Sometimes I think Natalia hit on this.
Yep.
They need paperwork or finances or documents, especially if it's in a divorce case. They don't have all the evidence there. And people, unfortunately, still come to mediation unprepared. All right. Even though you tell them in your letter,
Right.
please
Ah,
bring this, please bring that,
oh my
people
God.
don't. And so you find yourself, I just like to, if I'm gonna
Mhm.
do an adjournment or resets, I'd like to do it as soon as possible with inside of the mediation starting, so that we can know if we're gonna come back. All
Ideally,
right.
right?
Yeah. Any last other thoughts, guys?
No, that was, and I'm sure there's others,
Yes.
right? You know what I
Yeah,
mean?
one more that I really need to think is that because the mediation is voluntary, of course, the mediation might end because someone is just walking out. But
Mhm.
this is not something that is advisable to the parties, and it's very disappointing.
But emotions take over, and I've had that happen, and then I've saved it, and I've had that happen. Yeah, they're gone. So,
Yeah. Well, yeah, that one is a whole nother podcast topic, guys. But we can safely say, please don't walk out of your mediation. The mediator is the one who ends it. Okay. Yeah.
some,
Well, so tell me, no,
sometimes
clarify,
they end
clarify.
it,
I mean,
right?
the mediator is in control of the process. The
Right,
parties are in control of the outcome and what the results.
right.
So
Yeah,
just people sometimes getting out of it, just taking off,
that'll
or
do it.
ending the Zoom
Guess we're
meeting
done.
doesn't really help. All right, guys. So that's it for now. We'll come back and keep talking more with Ty. Thank you so much for listening and
Always a
watching.
pleasure. I love it.
Until next time. All right. Take care.
Bye.